Hello everyone. In this set of 14 presentations, an attempt is made to give an idea of the general principles governing the law of torts. The first and the second presentations attempt to introduce the law of torts. We all know that law is nothing but rules governing human conduct promulgated and enforced by the state. The body of law can be studied under two heads: the civil law, which covers various branches of law that confer rights and impose duties on individuals, which can be enforced through remedies provided under them, and the criminal law, which include the general penal code and various special and local laws which define offences and prescribe punishments for them. Law of torts is a branch of civil law. What is a tort? The word tort is derived from the Latin word tortum, which means twisted or crooked conduct or wrongful conduct. It is a kind of civil wrong or injury. Let us examine a few definitions of tort to understand the nature of tort. Winfield defined tort in terms of tortious liability. According to him, tortious liability arises from a breach of duty imposed by law, and this duty is towards the persons generally. The persons affected by such breach can redress his grievance by bringing an action for unliquidated damages. Fraser defined tort as a violation of a right of an individual which can be compensated when he files a civil suit for it. Salmond defines tort as a civil wrong for which an action for unliquidated damages is the remedy provided in common law. It is neither a breach of contract, breach of trust, or breach of any other equitable obligation. Now, before analyzing these definitions, it is important to understand certain terms which have been used in these definitions. Tort has been defined in terms of a violation of a right, a breach of a duty, and a civil wrong. Now, what is a right, a duty, or a wrong? Right is something to which I am entitled, that is, what others have to do for me. It could be a moral right or a legal right. Moral right is not recognized by law, whereas a legal right is recognized by law and can be enforced. Right to possession and right to reputation are examples of rights which one is entitled to possess. Duty. Duty is something which is owed by me, or that which is due from me, that is, that which I must do for others. Duty to take care, duty not to interfere with others' person or property are examples. Rights and duties are two facets of a single idea. They are correlative. I have a right to enjoy possession of my property. You have a duty not to interfere with my right to peaceful enjoyment of my property. Rights may be public rights or private rights. Public right is a right available to the public at large, while the private right is a right available to specific individuals. Right to use a public road, public park, etc. are public rights. Right to my reputation or enjoyment of my property is a private right. A public duty is the duty owed to the public at large, while the private duty is the duty owed to a specific individual. Duty not to disturb public peace is a public duty, but a duty not to interfere with my property is a private duty. The right that I possess may be available against a specific individual or against the whole world. Suppose I enter into a contract with B. My right to enforce the contract is available only against B, and such a right is called a right in personam. My right to peaceful enjoyment of property is available against the whole world, and anyone who interferes with this right can be sued in a court of law, and such a right is a right in rem. Wrong is a violation of a right or a breach of duty. It may be moral or legal. Moral wrong is an act considered as wrongful by a right-thinking man. When this is recognized by law as a wrong, it is a legal wrong. Legal wrong is a violation of a right conferred by law or breach of duty imposed by law. Public wrong is a wrong affecting the public at large, that is, rioting, kidnapping, murder, etc. are wrongs which affect the peace and order in the society and hence are public wrongs. Private wrong is a wrong affecting a specific individual. By trespassing into another's property, there is a violation of an individual's right to peaceful possession of his property and hence a private right. Remedy is that which rectifies or provides relief for a legal wrong or for harm, loss, damage, or injury caused by a wrong. Injury is the harm caused to the body, mind, reputation, or property of an individual. Now, injuria is different from injury. Injuria, which is a Latin term, denotes a violation of a legal right of another person. Damage is the loss or harm suffered by an individual. Plaintiff is a person who claims that his right has been violated and brings an action in a civil court against the wrongdoer, that is the defendant, for redressal of the wrong suffered. Defendant is a person who is alleged to have violated the right of the plaintiff and against whom a suit is filed in a civil court for redressal of the wrong suffered. Damages is the compensation paid by the defendant to the plaintiff for the harm suffered by the plaintiff because of violation of his right by the defendant or breach of duty imposed by law by the defendant. Now, liquidated damages are those that can be pre-estimated or pre-assessed. For example, in the case of contracts, the loss that is likely to be suffered by one party if there is a breach of contract by the other can be assessed beforehand by the parties and can be awarded to compensate the loss when a suit is filed for breach of contract. Unliquidated damages, on the other hand, are damages that cannot be pre-estimated by the parties but will be decided by the court on the filing of the suit by the party affected after taking into consideration the facts and circumstances of the case. Now, after knowing about all these terms, let us go back to the definitions. According to Winfield, tortious liability arises from a breach of duty imposed by law, which is a duty in rem, and it is redressed by filing a civil suit for unliquidated damages, that is, compensation for loss actually suffered from the breach, which should be assessed from facts and circumstances of the case. So here the breach is breach of duty imposed by law, and that is a duty in rem. It is redressed by filing a civil suit in a civil court. And here the redressal that is provided by the court is unliquidated damages, that is damages which would depend upon the facts and circumstances of the case, which would show the loss that has been suffered or the harm that has been suffered by the plaintiff for the violation of a right or breach of duty by the defendant. Now, according to Fraser, tort is a violation of private right of an individual which entitles him to claim compensation in a civil suit filed by the person whose right is violated. According to Salmond, tort is a civil wrong, that is, a wrong affecting an individual, not the public wrong, which is a wrong that affects the public at large. This can be redressed by filing a suit for unliquidated damages. So here again, the damages that would be awarded would be unliquidated, or that which cannot be pre-estimated, damages that cannot be pre-estimated. But a private wrong can be a tort, breach of contract, breach of trust, or any other equitable obligation. Hence, he excludes all other private wrongs except tort by excluding it from the purview of the definition of tort. Though none of these definitions covers all the aspects of law, Winfield's definition is considered to be the best by many jurists. What constitutes the elements of tort will be explained in the second part of the introduction in the next presentation. Thank you.